Good afternoon and welcome to the fourth meeting of the Honolulu Liquor Commission. Please silence all of your electronic devices, and if you're appearing before the commission today, please introduce yourself, spell your name, and if you're here to testify on any matter before the commission today, please come forward, identify yourself, and be sworn in by our Assistant Administrator, Ms. Sarai. With that being said, Commissioners, I see we have some action for some previous minutes.
Yes, Chair. Motion to approve the regular minutes of the 39th, the 43rd, and the first meetings, and the executive session minutes of the 39th and the first meetings as previously circulated.
Second.
It's been moved in second. All those in favor?
Aye.
I vote aye. The regular minutes of the 39th, 43rd, and first meetings and the executive session minutes of the 39th and first meetings are approved. Moving into the preliminary hearing, agenda item number 1, application number 18-13391 from Sunrise Inc.
My name is Takuya Tsutsumi. I am the president of the Sunrise Inc.
Thank you. Commissioners?
Yes. Question about the investigative report. There's a comment on the stairs that you need to access to get to that restaurant space at the top.
Yes.
Is that going to be a common stair for both premises, or how is that stair? Is that stairs going to be under another license?
The stairs only goes upstairs, so that's that stairway belongs to my company.
Okay, your company owns the bottom restaurant as
Yes.
well as the top
Yes,
restaurant.
both.
Now you have a license. You currently have a license for the whole thing under one license.
Under one license, but
So you're
the
gonna-
restaurant is actually not open yet, so.
Right. So you're going to delete a portion of the license.
Once this license is approved, yes, I would like to delete the previous license.
Now, is that stairway going to be under any license, or is it going to be?
Stairways.
We just want to make sure that that stairway is not part of another licensed premise, and you
No.
have to go through that licensed premise to get up to the other restaurant.
No.
So it's going to be removed from all premises.
I'm sorry.
So you enter a door and you walk the stairs
Stairways,
to this
yes.
restaurant.
Yes.
That stairway itself, who controls that stairway?
The Ichifuji restaurant upstairs.
Upstairs.
Yes. Controls.
But it's not going to be part of that licensed premise. But they do.
No,
they will
for the
control
liquor
that whole
license,
stairway.
yeah, that's my property, but the liquor license, that stairway is not included.
Okay.
And another thing about the door is the building ever going? You have control over that doorway
Yes.
that provides access to the licensed premises.
Yes.
And so, does anybody else control that doorway?
For upstairs, no,
Nobody else
Nobody.
controls, only you.
only me. Yes.
So the building shouldn't, that building door shouldn't be secured or closed when you're
The
During your
nighttime
business
always
hours.
open the door.
during your
Yes.
business hours.
Yes.
Motion to approve application 18-13391.
Second.
Been moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 1, application number 18-13391 is approved.
Thank you.
Thank you. Good luck.
Calling agenda item number 2, application number 18-14300 from Lava 2 Waikiki Inc. Mr. Lugo.
What was that? No, it's not number 2.
Agenda item number 2,
Oh,
application number 18-14300.
Hello, Richard McCall from Tiki Venture Inc., representing Lava Tube Waikiki.
Have you had an opportunity to review the investigator's report?
Hmm.
Do you have any changes or corrections?
No.
Commissioners, do you have any questions for the applicant?
Yes, sir. Mr. Cook, you understand that this is you're going to be taking over a existing hotel license.
Yes.
You do, and you're planning to get all the agreements in place with the operator.
We already have.
You have it already.
Yes.
Motion to approve application number 18-14300.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 2, application number 18-14300 is approved.
Thank you.
Thank you for coming. Calling agenda item number 3, application number 18-14593 from Moana Inspiration LLC.
Good afternoon, Mr. Chairman, members of the commission. To my right is Ching Lin. First name is spelled Q-I-N-G, pronounced Ching. She's a member of the applicant LLC and a record reflect Wayne Link as counsel. We have no changes to the investigators report.
Thank you. Commissioners?
Motion to approve application number 18-14593.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 3, application number 18-14593 is approved.
Thank you.
Calling agenda item number 4, request number 18-144454.
Good afternoon, Commissioners. Naomi Cole on behalf of the applicant. Present to my right is member Winston Wan. We have no changes to the investigative report.
Thank you. Commissioner?
Motion to approve request number 18-14454.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 4, request number 18-14454 is approved.
Thank you, Ms. Cole.
Calling agenda item number 5, request number 19-14640 for Murphy's Inc.
Good afternoon, Chairman, Commissioners, Ms. Arai, Don Murphy, Murphy's Bar and Grill. On the report, the only change I have is it says Friday, August 9th, and it's Thursday, August 9th. It's just a typo.
And I see this is your annual pigskin pig out
Correct.
benefit for our University of Hawaii Warrior team.
Illustrious football team, yes.
Yes,
Go Bulls.
go Bulls in black.
You got it.
You got it. Against Warriors.
Always been Bulls to me.
Back in the
Can
day,
I ask
it was
what-
the rainbow?
Can I ask why Ms. Harai's sign is gone?
We have no idea. I leave it there.
I thought I was going to have to call her Miss White.
I also see here, Mr. Murphy, that you're complying with the downtown neighborhood board's 10 p.m. curfew. on
Yes.
liquor. Thank you very much. We appreciate that. Commissioners, do you have any questions for the gentleman? Commissioner Miyashiro.
Mr. Murphy, the investigative report indicates that I think there's an estimate of 200 people,
Correct.
300 people, and then even 1,000. So we just want.
I don't know where that came from. It wasn't anything that I said. The most would probably be 200. 200 is usually what a max is at.
Do you have a maximum capacity for what you're trying to accomplish?
Well, when we have the street out there, yeah, about 200 to 250.
Okay.
Yeah.
Thank you.
hopefully they're all contributing.
Yes, hopefully.
Motion to approve request number 19-14640.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 5, request number 19-14640 is approved.
Thank you.
Thank you for all the good things you do for the community, Mr. Murphy. We appreciate that. Calling agenda item number 6, request number 19-14705.
Good afternoon, Chairperson and Commissioner. Zerai. Gabriel Provenza on behalf of licensee Safeway Inc.
Very good. Commissioners, do you have any questions?
Any questions?
No questions.
Motion to approve all Safeway stores under agenda number 6, request number 19-14705.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 6 is approved. Mr. Provincia, would you represent to this commission that none of the officers listed have been convicted of a felony?
Yes,
You
good
would,
from that.
for the record, thank you very much.
Thank you, Mr. Provenza.
Thank you.
I think it's right up.
Let's have
He's number 7 also.
agenda 7. Come on down.
And also 8.
Stay a while.
All right. Not a problem.
Come on down, have a set, and stay a while. So we are on agenda item number 7, request number 19-14706 from HIE Retail LLC.
Good afternoon, Commissioners. Zerai. Gabriel Provenza on behalf of HIE Retail LLC, the licensee.
Thank you. Commissioner? Commissioner, sure.
Mr. Provenza, as I understand the request, it's supposed to, this is a proposed merger of HIE Retail into Hawaii.
Inc. Yes.
Okay, so pardon my ignorance, but why did you submit articles of incorporation for Coco Oha Investments? What's that? What's the
There-
relationship?
The Par Hawaii Inc. was formerly known as Coco Investments, and there's been a name change. I believe on file we have the name change document as well
And that name changes,
to Par Hawaii Inc.
and is that registered with the BCCA as well, the name change?
Correct.
Okay, thank you.
Motion to approve request number 19-14706.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 7, request number 19-14706 is approved.
Thank you.
Calling agenda item number 8, request number 19-14707 from Midpack Petroleum LLC.
Good afternoon, Gabriel Provenza on behalf of Midpack Petroleum LLC, the licensee.
Commissioners, do you have any questions?
Mr. Provenza, for the record, can you repeat again who Coco Oha Investments Inc. is?
Coco Oha Investments Inc. Is the entity now known as Par Hawaii Inc., which will be the surviving entity in connection with this merger.
Thank you. Any questions? Motion to approve request number 19-14707.
Second.
It's been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 8, request number 19-14707 is approved.
Thank you.
Thank you.
I think I'm free for a little while now.
Thank you. Calling agenda item number 9, request number 19-14783 from JB Cajun Inc.
Hi, hello. Jason Higuchi, Higuchi from JB Cajun Inc., owner manager.
Thank you very much. Commissioners?
for this extension, for requesting this extension?
Some minor renovations to increase the dining area, and also with the what is that called, the entrance, we're just expanding that area also. The storefront, expanding the storefront.
Any questions?
Question. Are you removing a restroom from the existing space?
Yes.
And how do you plan? Do you have adequate facilities
The
elsewhere in the building?
Yes, the building has restrooms that were approved by Liquor Commission.
Oh, they were okay.
It's not in this drawing, but
How far are they approximately away from?
three shops down.
Three shops.
And when you say it was approved by the Liquor Commission, is it in another licensed premises?
No, it's part of the same building.
Part of the same building, but it's not inside another
No,
bar or
so the
restaurant?
drawing has my restroom and then it shows the building's restroom.
Your previous license
Yeah,
does have
yeah.
that that
Okay.
license,
Yes,
that
original.
restroom. Okay.
Thank you. Motion to approve request number 19-14783.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 9, request number 19-14783 is approved.
Thank you.
Thank
Good
you.
luck.
Calling agenda item number 10, request number 19-14791 from George's Corporation. Mr. Uyoka.
Good afternoon, Mr. Chair, members of the Commission, Ms. Hirai, Robert Uyoka on behalf of George's Corporation. At this time, we just want to notify the Commission and request the withdrawal of the previous approval. We had anticipated going to a merger on October 1st, 2018, but we have since decided not to. So we're asking to withdraw the previous approval.
Thank you very much, Mr. Uyoka. It's our pleasure.
Motion to approve request number 19-14791.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 10, request number 19-14791 from George's Corporation is approved.
Thank you so much.
Thank you, Mr. Uyoka.
Calling agenda item number 11, request number 19-14787 from James T.H. Lee Esquire.
Good afternoon, Mr. Chairman and Commissioners. James Lee representing Wei and Shu Group Inc., DBA Honolulu Skewers House. Seated to my right is Nien Chen Sai, TSAI, who's a member of the corporation.
Thank you. Commissioner?
How long has this, how long was the previous licensee been out of business?
Less than a year, but the former operator, the licensee, the Japanese restaurant owner is being less than cooperative.
What, less than what?
Cooperative with the transfer of license, so we are asking for a waiver.
Thank you for representing those facts to the commission.
Motion to approve request number 19-14787.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 11, request number 19-14787 is approved.
Thank you very much.
Thank you, Mr. Lee.
Thank you.
Calling agenda item number 12, request number 19-14812 from Mr. Keith Kiyuchi.
Good afternoon, Mr. Chair, members of the Commission, Keith Kiyuchi for Beer High 2 LLC. To my right is Lisa Kim, who's the wife of the owner of Beer High 2 LLC and the real manager of Beer High 2 LLC. We're still working with the bank. So it's possible we might do a merger of the two entities, but in the event the bank doesn't allow that, we're asking that the documents on file for the previous approved application be used for the new application.
So you would represent that there are would be no additions or
No.
deletions from those documented names that we have?
There would not be.
There would not.
Yes.
Thank you.
Mr. Kyuchi, how long ago were these documents?
You approved the license in, I believe, January, February of this year, so it's within the last 6 months.
Within the
Yeah.
last 6 months?
Yeah.
Thank you. Motion to approve request number 19-14812.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 12, request number 19-14812 is approved.
Thank you.
Thank you, Mr. Kyuchi. Commissioners gonna have some type of action on the adoption of decision and order.
Yes, Chair. Motion for the adoption of decision and order for agenda items 13 through 22 inclusive.
Second.
Moved in second, all those in favor?
Aye.
I vote aye. The adoption of decision and order agenda items number 13 through 22 inclusive are approved. Moving into adjudication.
Good evening, Joy Neely, Deputy Corporation Counsel, here for the adjudications calendar.
Thank you. Calling agenda item number 23, RB Sports Bar and Grill.
Hi, I'm Edward Gishwang, owner and president of 2535 Coin Court, RB Sports Bar.
You spell your last name for the record?
GSCHWENG.
I'm sorry, one more time.
GSCHWENG.
Thank you.
So the charge is on or about April 24th, 2018 in the city and county of Honolulu, state of Hawaii. Licensee had some form of music, dancing, and or entertainment, including but not limited to electronic gaming devices, card playing, and table games, to wit, beer pong, on the licensed premises without prior authorization or approval from the Liquor Commission, in violation of Rule 38247.1a of the Rules of the Liquor Commission of the City and County of Honolulu.
Sir, how would you like to plead? Would you like to admit the allegations, deny the allegations, or no contest to the allegations?
I'd like to plead no contest with explanation.
Motion to accept the no contest plea.
Second.
Moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 23, the no contest plea is accepted.
Ms. Lee, your recommendation.
Neely. Since this is a first violation, the recommended penalty is $250.
So my explanation is we've been doing this tournament and there's no alcohol in the cups or anything. We've been doing it as lawfully as possible, completely lawfully. We've been doing this for maybe about 7 years. I guess I feel like there's kind of like a gray area because we've had inspectors come in on the nights. We only do it once a week, so it's set up for 5 hours. So we've had inspectors come in and watch this event go on for a long time now, and they've never told us that those tables had to be registered or ever had a problem with it. So now all of a sudden, I know a lot of other bars started doing it, and I'm not sure if we had like a supervised tournament. It was for the guests were allowed to win like prize money for winning the tournament. So it's like kind of like a dart tournament or a pool tournament, but it was like beer pong with water in the cups. We've had rules and stuff posted saying that drinking is not a part of the game. You know what I mean? You're allowed to drink your own in the area, but so what I'm trying to say is that we weren't sure that we're supposed to register those because they're not always up. They're only up like 5 hours, and then when there wasn't inspectors present, they never told us that we were in violation of any of that.
Can you walk us through how the game is set up? So who is allowed to enter? What is the night? What are
that night we have like a $5 cover charge, and anybody that enters is allowed to play. It's free to enter the tournament. We have them set up on top of our pool tables, and there's triangle with cups of water inside, and the players just throw the cup in, eliminate the other players' cups, and then they win and move on to the next round of the tournament until there's one winning team. That's pretty much the gist of it.
what do the winners win?
We were doing a $200 cash prize if there is 30 or more teams.
I don't know, lawyer last name, so sorry. So the section that's you've been cited for specifically prohibits card playing and table games without prior authorization. Are you aware of that?
Yes.
Because as I understand the section, card playing and table games do not necessarily involve alcohol. And what I understand you're saying is that because there was no alcohol in the cup, there might be some technical violation or not. Is that what your position is?
Yeah. Well, actually, I was just unaware that those tables needed to be registered because it's a game kind of like pool or darts, you know, like a bar game. But it's there. We set them up only for 5 hours once a week, and so I wasn't sure that it needed to be registered.
In the future, I suggest you contact administration if there's anything gray to make sure you're complying with the rules.
Yeah.
And the fact that someone, whether it's an investigator, inspector, may not have cited you on prior occasion, to me does not excuse ongoing non-compliance.
Okay.
Are the tables set up and then removed?
Yes, they're removed every night, set up and removed every Tuesday.
My motion is to approve the recommended fine of $250.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 23, the recommended fine of $250 is approved.
Thank you, sir.
Calling agenda item number 24, RB Sports Bar and Grill. Please introduce yourself again for the
Edward Gishwang, GSCHWENG from RB Sports Bar and Grill.
The charge here is on or about May 9th, 2018 in the city and county of Honolulu, state of Hawaii. Licensee had some form of music, dancing, and or entertainment, including but not limited to electronic gaming devices, card playing, and table games, to win beer or water pong on the licensed premises without prior authorization or approval from the Liquor Commission, in violation of Rule 38247.1a of the Rules of the Liquor Commission of the city and county of Honolulu.
Sir, how would you like to plead?
No contest with explanation.
Motion to accept the no contest plea.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 24, the no contest plea is accepted.
So for adjudication purposes, this is considered a first violation, and the recommended penalty is $250.
So, of course, it's the same thing again. I was unaware of the formalities of how this works, so we were doing it up until I was going to have this hearing, and then to know that it was not allowed anymore or so I wasn't, and then Liquor Commission came in again, the inspectors, and then cited us again, so I was like, oh, I'm sorry. So after that, we took them down completely and never brought them out again. But I thought I had time to wait till this happened to find out that I was supposed to leave them down.
Motion to approve the recommended fine of $250.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 24, the recommended fine of $250 is approved.
Thank you, sir.
I have can I ask you something?
Let me make a comment.
Oh, sorry.
We'll allow you to
Okay, I'm sorry.
ask a question. Okay, so you had your first violation on April 21st.
Yeah.
24th, correct?
Yeah.
Okay, and there was some uncertainty in your mind as to whether you were doing the right thing or the wrong thing.
Yes,
correct?
exactly.
Okay, why didn't you come to the administration and have them determine whether you were doing the right thing or the wrong thing instead of continuing and being cited again on May 9th, 2018?
I was under the impression that this hearing would have came a lot sooner, and I was going to find out the answer from you guys.
No, we're only here to handle the adjudication.
Okay.
You know what I mean? The administration can answer all questions about the
Okay.
rules or the statutes. Our job is just to decide.
Okay. I did also go and try to register them, and they all got denied to register the tables after.
Let me continue on the dialogue. Right? So were they denied before you were issued a violation on May 9th?
No.
Okay, very good.
They're denied after.
Okay, thank you.
Yes.
to agenda item number 25, Enquiria El Rancho.
Thank you.
Madam Prosecutor, agenda item 25, do you have a recommendation for the commission?
Oh yeah, that's right. That's right. Okay, so yeah, Neil Gota requested a continuance to until August 30th, and there's no objection.
Do you have any objection?
No objection.
Motion to continue agenda item 25, Aquaria El Ranchero LLC to, I'm sorry, what was your date?
August 30th.
August 30th, 2018.
Second.
Been moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 25 is continued to August 30th. Calling agenda item number 26, Aquaria El Ranchero.
Likewise, there's been a request to continue this to August 30th, and I have no objection.
Motion to continue agenda item 26, Aquaria El Ranchero LLC to August 30th, 2018.
Second.
Moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 26 is continued to August 30th. Moving on to agenda item number 27. Blue Ribbon Bar and Grill.
Good afternoon, Grant Kidani and Pam Higa appearing for Blue Ribbon.
The charges in this case is on or about December 16th, 2017 in the city and county of Honolulu, state of Hawaii. Licensee permitted Joseph Texera to possess or distribute illicit or illegal drugs on the licensed premise in violation of Rule 38478.05A of the Rules of the Liquor Commission of the city and county of Honolulu.
Would you like to plead?
Well, we already pled not guilty. This was continued.
This is continued. Okay, I'm sorry. So this is for penalty phase only?
This was for hearing today.
Contested hearing.
Okay. So then you need to replete again for the record, please.
Yeah, on not guilty.
Excuse me. We
Right.
need.
Admit the allegations, deny the allegations, or no contest to the allegations.
Deny.
Motion to accept. No?
No need to accept or deny.
Alright, so we're gonna move you folks to the end of the agenda.
Okay.
Calling agenda item number 28, Miley Pink Market. Agenda item number 28, Miley Pink Market. No response, Madam Prosecutor.
Can I go ahead and make my recommended or read the charge?
Can you prove that this licensee was properly served?
Oh,
Are you requesting a default?
I'm requesting default, yeah. I have the service sheet here. The operations manager received the notice.
Commissioners?
Ms. Neely, had your office been in touch with anyone from the licensee?
I attempted to contact them, but I believe I left a voicemail, but didn't hear back.
And what is your recommendation for penalty?
So there are two charges. For the first charge, it's a first violation, so the recommended penalty is $500. Do I need to read the charges?
If you could just
Yes.
clarify, because the agenda only lists one matter.
Oh shoot! I'm sorry, I had the wrong. Okay. I'm sorry about that.
Let's start over to make sure that
Okay.
was served, please.
Yes. The licensee was served. Yes.
Can we have a recommendation for the default judgment?
The recommendation for the default judgment is $2,000 because this was a gambling violation.
Thank you. Let me ask you the same question, Ms. Neely. Did your office attempt to contact the licensee?
Yes.
How was that done? What were the-
Via telephone call. I called the vice president who was listed on the service sheet. The number.
Motion to enter a default judgment in the amount of $2,000 for agenda item 28.
Second.
Moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 28, a default judgment in the amount of $2,000 will be issued. Calling in agenda item number 29, 808 Hula Hut.
Good afternoon, Mr. Chair, members of the Commission, Keith Kiyuchi for the licensee. To my right is Sol Ok Cordell Chu, last name Cordill-Cho. We waive reading of the charge and a plea of no contest.
Motion to accept the no contest plea.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 29, the no contest plea is accepted.
The recommended fine for this first violation is $2,000.
First violation?
Gambling, Mr. Kyuchi.
No, that's not what she told me on the phone.
Okay.
I thought you said $1,000 first violation.
Oh,
Can we have a short recess, please? You can, Mr. Kyuchi, you can talk with the prosecutor. Back on the record. Madam Prosecutor, do you have a recommendation?
I believe I may have told Mr. Kyuchi that the standard fine for or the recommended fine for a first violation was $1,000.
What is your recommendation to the commission?
So I'll stick with what I recommended to him, so $1,000.
You recommended $2,000.
I've been informed that going forward we will be.
So you amended the recommended fine of $2,000 and propose a fine of $1,000.
Correct.
Mr. Kyuchi, would you like to comment?
Yeah, my client has had all of the machines were pot of gold machines, and they've all been removed from the premises.
When you say all, how many are we talking about?
3.
And you've advised your client as to what is allowed by the commission and what is not?
Well, this goes beyond that because this was an HPD bus.
Yeah.
So I've had that conversation.
Where are these machines now?
They're not in her premises. The vendor took them back.
And I know that the prosecutor told you what is the standard or the general recommendation for first time violations, but we are well within our rights to charge a maximum of $2,000 or even suspend this licensing.
I understand that. That wasn't my issue. That wasn't my issue.
I'll make a comment too, because I think you have a right to rely on the prosecutor's comment to you, but we're not bound by the recommendation.
I understand that, but there is a certain, there's a representation and there's a practice,
I agree.
and that's all I'm relying on. Now, I will tell you, I didn't tell my client what the recommended fine would be, but I did tell my client what the next steps were, and that occurred when she came into my office. So the first thing she did is turned off the machines. Second thing she did was call the vendors. Third thing that happened, vendors removed the machines.
Thank you.
We're also within our right to, the investigators could have issued a violation for each of the machines that was there at the time.
I understand that. But this is the first time she's had any type of violations like this. She's been fully advised. I mean, if she commits another violation after that, so this is a different story.
How long has she owned the license premises?
19 years.
My motion is to approve the recommended fine of $1,000.
Second.
Then moved in second, all those in favor?
Aye.
Aye.
I vote aye. Agenda item number 29, the recommended fine of $1,000 is approved.
Thank you.
Thank you.
On agenda item number 30, A Stop Convenience Store.
Good afternoon, Mr. Chairman, members of the board. My name is Stephen Wong. I asked you to waive the presence of the licensee. Basically, he only speaks Korean, and so if he needed to be here, we'd have to waste money to hire an interpreter. It's our intention to just plead no contest.
Okay, so Mr. Wright, correct me if I'm wrong, it's my understanding if your client requests an interpreter, that we will provide one
Yes.
at no charge to the licensee.
Yes, but there's no sense if we're going to, we weren't going to fight it, so
Okay.
no
I
sense
want that to
having.
be- I want that to be on the record, so
Sure.
you understand that, okay.
I told the prosecutor to cancel the interpreter.
And you're representing to the commission that you are going to relay everything that occurs today to your client?
Yes.
Can you read the charge, please?
On or about March 24th, 2018, in the city and county of Honolulu, state of Hawaii, licensee sold, served, or furnished intoxicating liquor to a minor or allowed consumption of intoxicating liquor by a minor, specifically Edna Lynn Nakapoi, at the licensed premises in violation of section 28178B1A of the Hawaii Revised Statutes.
Plea no contest.
Motion to accept the no contest plea.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 30, no contest plea is accepted.
The standard recommended penalty for a first violation is $1,000, but I will note that licensee's representative has told me that licensee no longer has a license, hasn't applied for renewal of a license, and has actually shut down the business.
Actually, if I could speak to the board, I could be more detailed.
Ms. Neely, I would like your recommendation first.
So the recommendation is $1,000, but just with that note.
Thank you. Mr. Wong.
I would ask for a decision of no payment of any monies. I feel that my client has already suffered enough. First of all, this wasn't intended. He's had this convenience store for, I would say, over 30 years. He's been tested several times in the past. Previously, and I've showed the prosecutor already that he received certificates of commendation that he followed the liquor laws. I could let you see them if you want, but I gave it to the prosecutor for zero or as minimum as possible. So anyway, this whole thing was not intended, but the fact of the matter is he's 74, he's elderly, his mental capacity is just not there anymore. So we advised him that he should just shut his business. So he closed his business, even though the lease still has about seven months to run, because we just can't afford to do this violation again. And so, it was more thorough to him. But the bottom line is he closed his business. He's already been penalized because criminal proceedings were brought against him. We pled no contest at that hearing. The court already fined us $230. Plus, he has to be monitored for a year. He can't travel without the court's permission. He suffered great stress because of this, because he's a naturalized citizen from Korea. So unfortunately, with their culture, this kind of thing that it's now criminal, it gives him anxiety and stress every night. Can't sleep. We just want it to be done with, so that's why we're not even fighting it, and just move on with his life.
When did the business shut down?
Excuse me.
When did the business shut down?
We shut down June 30th when the liquor license ended, and at that point we just gave everything away.
So you did surrender the license that you didn't file
It expired. I had asked the other prosecutor if I needed to actually turn in the original one, and they said I
but
didn't.
you haven't
need to.
renewed it.
We have not renewed it. We just turned in the liquor sales, the one that's due the end of July 31st. I actually walked it in last week Friday.
And Madam Prosecutor, is this license still in effect?
No. Oh, you mean the expired license?
Is it still in effect or it has not? Has it been put in safekeeping or?
My understanding is that there's no license currently in effect.
The license has not been renewed, correct?
It has not been renewed.
Alright. My motion is to approve the recommended fine of $1,000. However, we'll suspend collection of that for a period of 1 year.
Second.
Been moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 30, the recommended fine of $1,000 is approved. However, collection of the $1,000 will be suspended for a period of 1 year.
Thank you.
Calling agenda item number 31 for Go to Mini Mart.
To my right is Jennifer Kim. She is the owner. She is present with counsel Wayne Luke. We waived the pleading of the charges. It's a service to minor and plead guilty.
We have a new feed from Mr.
Oh.
Luke. Admit, deny, or no contest.
Admit.
Ms. Neely.
Um,
I'm sorry. Motion to accept the plea.
Second.
Been moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 31, the plea is accepted.
For purposes of this, for adjudication purposes, this is a first violation, and the recommended fine is $1,000.
We have really no comment on that. We have a problem with that the person that sold the liquor is her son. And he was very careless. That's the only word we can use for it in this particular matter.
And what is the licensee doing, if anything, to prevent this from happening in the future?
Well, I've been training him because he can take over the business, but somehow he made a mistake. So we do train the person. Actually, he even got a ID from here as a manager. So we are training, and we're trying to look for somebody perfect by which we cannot find, because he been doing this for so many years, but suddenly that happened. So hopefully it doesn't happen again, and I would talk to him every day actually. So hopefully he doesn't do that again. But it is just human being. It's really very hard to run a small business with not many employees. I heard somebody is closing down, but it is very difficult. But I am training him every single day, and he won't do it again, as according to him. So yeah, I'm sorry about this, but it won't happen again. Thank you. And I will fire him if he ever.
Was this part of our compliance effort?
Yes.
Was the ID asked for?
Was the did not ask for identification. No.
Right. Please work on it.
Yes. Ms. Kim, how long have you been in business?
I've been almost 13 years, 14 years.
How long has your son worked for you?
Pardon me?
How long has your son worked for you?
He been there about 5 years, but he's still going school. So anyway, he's 29, but he's continuing his semester and everything. So yeah, he only work at night, and he does have some health problems too. So I think he was very tired. But we don't have an excuse. I'm sorry.
Yeah, and I appreciate that, but I heard you say you want to pass the business on to him, but you understand we take these offenses and violations very seriously.
Yes.
And can and we do have the authority to revoke the license so that there will be nothing for him to have. Can you
I
please
understand.
explain that to him?
I did.
Tell him we said that from the commission during this.
Of course, sure.
Thank you.
We understand. Thank you.
Motion to approve the recommended fine of $1,000.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 31, the recommended fine of $1,000 is approved.
Thank you.
Thank you.
Calling agenda item number 32, Kalama Supermarket.
Good afternoon, my name is Daniel Lim. I'm the CEO of Palm Supermarket.
The charge is on or about April 24th, 2018, or charge 1. On or about April 24th, 2018 in the city and county of Honolulu, state of Hawaii, licensee sold, served, or furnished intoxicating liquor to a minor, or allowed consumption of intoxicating liquor by a minor, specifically Edna Lynn Nakapoi, at the licensed premises in violation of section 281-78B1A of the Hawaii Revised Statutes.
Sir, as to charge 1, how would you like to plead?
No contest.
Motion to accept the no contest plea to charge 1.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 32, the no contest plea is accepted.
And as to charge 2,
That we actually had the license there. Our manager was off that night, and
you
I couldn't.
admit, deny, or no contest?
No contest.
Did you read that?
Yes. Oh,
I didn't read it.
I'm sorry. Go ahead.
Okay. Well, charge 2 is on or about April 24th, 2018 in the city and county of Honolulu, state of Hawaii. Licensee failed to conspicuously post and expose to view convenient for inspection its license on the licensed premises in violation of section 281-71 of the Hawaii Revised Statutes.
I'm sorry, sir. Your plea again?
No contest.
Motion to accept the no contest plea for charge 2.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 32, charge number 2, the no contest plea is accepted.
Ms. Amy, what is your recommendation for charge 1?
For a first violation, the recommended penalty is $1,000.
And as to charge 2, your recommendation?
It's a first violation, so the recommendation is $100.
Sir, as to charge 1, sale to a minor. What happened?
We train our cashiers, and we've actually changed the POS system to actually require the cashier to enter a date, the birth date for the customer. And this was a newer cashier, and she's been trained, but after the incident, I actually directly asked her why. How could this happen? You guys are supposed to put the date on, the birth date on the ID into the system, and there should be zero, mistakes. And she was saying just to go faster, she would occasionally type in, she'd have a number in her head, so it would take her too long to read the ID and put it in. And so, I was actually there when, this happened, and so I had, on the spot, showed my displeasure with the way it was handled, and now we do train and remind again and again with the managers. The majority of our liquor sales is rice wine, Korean rice wine. So the majority of our customers who are buying it are more foodie or cultural people, and so they don't come across a lot of customers who are looking to buy hard liquor or anything like that. And so I think it just kind of makes them less aware of the customers that are passing by. But now we enforce that they have to be aware of every single customer, regardless of who they are or what they think, and make sure everything is always checked.
And this is not uncommon for licensees to have the same problem as you.
Yes.
That employees are finding a way to circumvent
The system. Yeah.
Do you have a way to look into your POS system reports, maybe daily or weekly, to see what numbers are being punched in by your cashiers? Do you have that type of capability?
I haven't thought of that, but I think I'll try to check, because we do have a lot of there's modular. The system is modular, so we can check different reports.
Because then if you can see daily that a date is being pushed in too many times,
Right.
there's not too many people with the very same birthday date
Right.
here.
I will check with our POS.
And was this a vertical? Was an ID asked for? Presented?
Not in no.
As to charge one, my motion is to approve the recommended fine of $1,000.
Second.
Moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 32. The recommended fine for charge number one of $1,000 is approved.
And as to charge two, sir?
So we actually did have it posted. When the inspector was there, I just didn't realize it was on the wall. I thought I was looking on the column, and so while she was there, I couldn't find it for her. But the next day, she actually came back in because there was an error on the date of the violation. She put the wrong date on there, so she needed to get me to sign it again, and I showed it to her. And so she was like, "Okay, good, you put that on there." I don't know if she put a note of it, but I also have a picture of it that's mounted on the wall right now too. See it.
Motion to issue a letter of reprimand for charge two.
Second.
Moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 32, charge number 2, a letter of reprimand shall be issued to the licensee.
Thank you.
Thank you.
Good luck.
Calling agenda item number 33, Target Store T-2410.
Good afternoon, Chair O'Donnell, Newton Chu on behalf of Target Store 2410. To my right is Shannon Bell, team leader of this particular store. We waive reading of the charge and plead no contest.
Motion to accept the no contest plea.
Second.
Moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 33, no contest plea is accepted.
Ms. Neely.
This is a first violation, so the recommended fine is $1,000.
Mr. Chu.
Yes, this is an unfortunate incident where one of their team members, as they're called, their employees, was called over to assist an underage cashier, and he looked at the ID but typed in a different date, and he was terminated. And since that time, I can let Ms. Bell explain, but there's been retraining throughout the store, and they have over 400 employees. And if an employee fails, it's a very unfortunate.
I would like to hear about the training.
For sure. I have there's an online training that Target provides, and it actually involves you going out on the floor and working on the register. And at Target, you may not override any kind of prompt. Any kind of alcohol that comes through our register requires the enter of an ID date, no matter the age of the guest or customer. The training, we also have at every register, and I have a copy of it if you'd like. It also gets scored, and so I do have the score of this particular team member and proof that he did take his quiz and that he was provided the training. And I mean, since this incident, when I got the phone call that this happened, my immediate instruction to my team was to go and immediately train anybody that was working then, and then the very next shift of anybody who is been trained to ring on the register to be retrained. And in particular, emphasize the personal consequence that you face if you make a mistake, because I think that is in Target's training could have been even more emphasized, and so that's what we've chosen to do at the stores to make sure they understand that there's a personal consequence you face if you make the wrong choice.
And was an ID was asked for and presented? Was it a vertical ID?
Yes, it was.
Have you increased the training about what a vertical ID means to you?
I have not. I think that's a good point. I can absolutely involve that into my next
A vertical
round.
ID being presented should be a major red flag for any employee in your store.
Okay, I will add
Because
that.
it means it was issued prior to them being of age. Okay. Which means they're probably still not of age.
Mm-hmm.
It's a very easy way that
Right.
it has been created to help cashiers not serve liquor to minors. And it seems like it's being ignored not just by you guys but by lots of other licensees and their employees.
I'll make sure that I share that with my team and also my other peers, my other store team leaders.
They were asked it was presented to a minor who was not allowed to sell the alcohol. They asked for a manager. They did the right thing.
Not a manager. It just requires someone who is of age to sell alcohol. And this particular person was at the next cashier register next to her, and he asked her what she needed, and she said it's alcohol. And he came over. I didn't view the video, but this is from what I understand, what I was told. And he came over. He looked at the ID. He did not take the ID into his possession, though. And entered a date.
Ms. Bell, I heard you say that with your system you cannot override putting in a birthday. Did I hear that correctly?
Correct. Like you may not make a judgment about someone's age. You absolutely have to put in a birth date.
But you're not. I think I'm not understanding because
Sure.
the citation here was the person, the team member typed in a different date than the identification
Correct.
showed.
Yes. Yeah.
So there is the possibility your team members or managers could put a different date than what's presented.
Correct. And that's why we've, since this incident, have stepped up the sharing of the personal consequence. If you make that choice as a team member, as a person, you have the risk of receiving a criminal offense and paying a hefty fine. So.
And I think I saw you and Mr. Chu in the audience when Vice Chairman made a comment to the prior licensee that along the lines of, are you able to do spot checks through your database to see if a common birth date is used or input by team members?
Yeah, let me address what I was. Thank you for looking at us while we're talking. But no, I have checked because, as you know, I've been with you before, and we have many different retailers that we're having the same problem. There's a law, HRS 487J, that prohibits the scanning of driver's licenses, and Target was one of those companies that got a letter from the ACLU that says if you collect data from any customer from their driver's license, we will sue you. And that happened back in 2012. So the collection of data, like what you were suggesting, that we go back and check what birth dates our customers have, I think might be
That's not what I was saying.
Okay,
that's what. Look at if there's being a date that's being repeated.
I agree with that. My first impression was I would like to know which employees, on behalf of the employer, who are violating our policy. We would like to know that, because then we would know who is violating our policy and they could be subject to discipline. I agree with you there. I was whispering to her in the audience. I didn't notice that loud, but I said, that we cannot collect. That's what I was talking about.
Okay, what I'm trying to get at is I want to make sure, people are people. They're going to make error and sometimes intentionally override the system. And I want to make sure you folks are proactive so that you do something, whether if you cannot, and it's illegal to collect data, I understand, appreciate that, but perhaps you do spot checks, or you can have secret shoppers or something to make sure that the cashier's team members do not make mistakes and do not intentionally override. And I'm just suggesting you consider those.
We appreciate that.
All right. Motion to approve the recommended fine of $1,000.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 33, the recommended fine of $1,000 is approved.
Thank you.
Thank you.
On agenda item number 34, Don Quixote.
Afternoon, Mr. Chair, members of the commission, Mr. Rai. Craig Nakamura, attorney on behalf of the licensee Don Quixote. And with me today, to the far right, is Makiko Wakukawa, who's the director of Don Quixote, and also Jeff Kagawan, who is the store manager. And I've given the spelling of the names to the court reporter. We waive the reading of the charges and plead no contest.
Motion to accept the no contest plea.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 34, the no contest plea is accepted.
This is the first violation and the recommended fine is $1,000.
Mr. Nakamura.
Just very briefly, I'd like to ask Mr. Kagawan to give a brief explanation of what occurred and then also discuss what they're doing to make sure this doesn't happen again.
Thank you. Yes.
On a data violation on May 19th, the cashier basically misread the date on the IDA and punched in a different date that was on the ID. She brushed the judge. It was a vertical ID, and she should have taken her time. Since then, in fact, I was present on site at the time. Following the citation being served, she was immediately suspended by me. Since then, towards the remainder of the month of May, we conducted a retraining of all cashiers before the end of the month. There was a memo and also an advisement from our trainer's office to assist in conducting the training. We've also redid the signage at the register, kind of also reminding the cashier by what date that they should be looking for, especially the year, being that the ID was 1998, and she input in 1996, or was it? I'm sorry, she input in 1996, and the year was 1998. We have a new front-end manager, so she took the lead by conducting random testing also on the cashiers on shifts on Thursdays, if they're performing the right function as far as asking the question, are you of legal age, and also doing the ID checks for liquor purchases. Every Thursday, we also implemented on our overnight shift. Every Thursday, the overnight head cashier would be inputting into our POS system like a flash message that goes out to the registers, reminding them basically to check IDs for liquor purchases. That way, all cashiers will be more attentive with purchases. This message basically flashes every 5 minutes and is turned off by the following morning. And then towards the rest of the week, the random checks would continue until all cashiers on the roster is done, and then a new cycle starts off from the next Thursday of random checks by the front-end manager. Also, most recently, our POS system was revised to where the cashier cannot bypass the entry of the birthday. Basically, when you ring up an item, it will prompt you to enter a birthday. Prior to this, the cashier was able to bypass it by getting a certain key. That since then has been disabled. So now it forces the cashier to definitively check for an ID and enter an actual birthday. The last thing we're also doing is I submitted a request to our IT department, which in turn submitted a request to our software company for the POS system, inquiring as far as checking the birthday entries, if there's anything repetitive. Currently, we're awaiting response from that software company if it's possible, and what will be the procedures as far as generating some type of report, whether it be printed or viewable on screen by cashier. That was a lot.
We'd be happy to answer any questions, but we really do take this matter very seriously. We try to implement as many different changes as we can. We appreciate the suggestions made by the commission. I pass those on, and we try to implement all of those changes as well. So we apologize this happened, but thank you for listening.
We recognize that, Mr. Nakamoto. We realize that we are an island community, and we have families and friends to friends, and those are the ones that we worry about. A manager's gone, come. You know what I mean? It happens to every. It's not a laughing matter. It happens. I apologize. Sometimes it's not this. It's that. But it can happen. And some innocent member of our community is going to get hurt because of friend to friend or family members sharing a manager's gone. Thank you.
Thank you.
Type of action, please.
Motion to approve the recommended fine of $1,000.
Second.
Moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 34. The recommended fine of $1,000 is approved.
Thank you very much.
Thank you, Mr. Nakamura.
Keep up the good work.
Good afternoon, Mr. Chair, members of the Commission, Ms. Hirai, Robert Uyoka on behalf of Walgreens. We did submit a written request on July 23rd for a continuance of this matter to August 30th. This is our first request. Also discussed this matter with Ms. Neely on July 24th. We understand she has no objection to the request for continuance to August 30th.
That's correct.
August 30th, you said?
Yes.
Motion to continue agenda item 35 to August 30th.
Second.
Moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 35 is continued to August 30th, 2008.
Thank you so much.
Thank you. Calling agenda item number 36, Num Num.
Afternoon, Chairperson and Commissioners. Mizurai, Gabriel Provenza on behalf of licensee. To my right is John Payton, last name Peyton. He's the retail operations manager for the licensee. We waive reading of the charges and wish to enter a plea of no contest.
Motion to accept the no contest plea.
Second.
Been moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 36, the no contest plea is accepted.
For adjudication purposes, this is a first violation, and the recommended fine is $1,000.
Mr. Provenza.
Thank you. First and foremost, just like to apologize on behalf of the licensee that this occurred. And I have John here who's able to answer any questions that you have. I've gone over with him the policies that they have in place, which are robust and are continually being improved upon. You know, when I come to the commission and I listen to the other adjudications, I try to relay what I'm hearing, and I think for the most part they've implemented or tried to implement just about everyone that I've relayed to them. So I'll maybe let him explain a little bit about what they do to prevent sales to minors, and then we're available to answer any questions that you have specifically relating to this violation.
I would like to know what specifically happened for this incident.
Sure.
So so specifically for this situation, the cashier did ask for an ID. It was a vertical ID, so as you pointed out, that should be an obvious time to stop the sale. Cashier took the ID. Our expectation is that any ID that you ask for, you either hand key or scan in the ID to capture the birth date and allow the system to inform you whether or not you should continue with the sale. The cashier in this case did that. They actually keyed in the birth date. The system prompted them not to continue with the sale. For some unknown reason, the cashier decided the system was wrong and voided the sale, and then re-rang it and followed through with the sale. So a little frustrating of a situation. I mean, we very much take age-restricted sales serious. We have a lot of training around the program. You know, we constantly emphasize it. In this case, the cashier followed the proper steps initially, and the system worked the way it was supposed to. And unfortunately, for some reason, she made a decision to ignore it. So.
What happened with this particular cashier?
So we take these situations very serious. As soon as we were informed of it, we suspended the employee, conducted our own review of the situation, and then terminated them.
I have one question for the licensee. 2260 Kamehameha Highway. Where is your business located?
Yeah, so this one, and I before we walked in, I was kind of questioning the date to it, or the address. So that's our location on we call Kalihi Camp, like on Nimitz. So it's next to the there's a club store right next to it. The name slips my mind. So it is the proper address, but I don't think it really represents where you would think it would be. So it's really predominantly entered through Nimitz as you would be heading westbound.
Alright, anything further, commissioners? Motion to approve the recommended fine of $1,000.
Second.
Then moved in second, all those in favor?
Aye.
I vote aye. Agenda item number 36, the recommended fine of $1,000 approved. Calling agenda item number 37, Nam.
Good afternoon, Chairperson, Commissioners, Mr. I. Gabriel Provenza on behalf of the licensee. To my right is John Payton, Peyton. He's the Retail Operations Manager for the licensee. We'd like to waive reading of the charges and request to enter a plea of no contest.
Motion to accept the no contest plea.
Second.
Moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 37, the no contest plea is accepted.
Ms. Neely.
For adjudication purposes, this is a first violation and the recommended fine is $1,000.
Mr. Provenza.
Again, apologies on behalf of the licensee that here's the sale to minor occurred. John Payton can answer any questions that you have about the specific violation, and I guess maybe we just point out for the commission's information that one of the things that they implement is their own secret shopper. Twice a month, which is where they're testing age-restricted sales. So that's something they're paying a third party to do. You know, it's on top of what the state is doing. You know, to help ensure that sales to minors aren't occurring. It's also helping them improve their system.
What happened on this particular incident?
To back up a little bit, I mean it's embarrassing to be here for two violations. So the violation we discussed previously happened, I believe April 8th, if memory serves me correct. This one happened approximately 2 weeks later.
At a different location.
So in between that time, when we had that first violation occur on the 8th, that next morning I actually sent an email out to all of our store managers and district managers and shared my concerns with what had happened on the 8th and made sure we really emphasized the steps that we need to take to avoid age-restricted sales. As a part of that process, we went through and revised some of our own policies and procedures, including when we hire new employees, as part of their new hire orientation, we go through the age-restricted sales process, train them on what that looks like, and we actually have them sign an agreement that's called age-restricted expectations, which highlights not only the process that needs to be followed in the state laws, but also the personal consequences. So we went back and revised that between these two incidences and highlighted those personal actions that could take part in terms of a fine, potential criminal charges. And so through that time, we went out and had every employee in the company review that and re-sign it. So when this incident happened on the 21st, a little bit similar to the other one, customer came in, they had the vertical ID. Again, that should have been a sign not to move forward with the sale. The cashier chose to give the ID back and not scan it in, which would have been our expectation, and instead keyed in a date. When we spoke to them, they said they had misread the ID. I'm not really sure how. Part of what sort of stood out with this situation was the cashier did not inform us of the violation for about a week later. And when we asked why, what they specifically said was, we know we just talked about it and I know I'm going to get fired. And so, we asked, okay, you understand the laws, you understand the expectation, why didn't you just take the time to scan the ID in? And there really wasn't a valid explanation there. So as soon as we found out about it, we placed her on suspension and then did move forward with a termination.
I have a question. You have a store located in Kaneohe?
Not a company owned and operated store. So we do have franchised or leased stores, but not that we operate.
Winwood City Shopping Center?
Yeah, so for that location we own the fuel, but we don't operate the C store.
Motion to approve the recommended fine of $1,000.
Second.
Then moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 37, the recommended fine of $1,000 is approved.
Thank you. Thank you, Mr.
Thank you for your
Provenza.
time.
Before I call agenda item number 38, is there anybody here that we have not called your name or any?
To go back to
We have to
27.
go back to 27.
27, that's what I read. Okay. Calling agenda item number 27, Blue Ribbon Bar and Grill. Okay, before I continue and call the agenda, do we have any witnesses that will be appearing before the commission here today? They need to be excused.
The owner is here, so
The owner
she
is
can
here.
stay, right? Yeah.
Yeah, I have one investigator, but he's not in the room.
Yeah, she can wait.
I never received
Pardon?
a list of witnesses.
Not sure we did, but it's only basically she was just there working. Both people were there working, and if they wanted to ask them anything, that's why we brought them. But beyond that, it's not going to be anything substantive. But we just had them here in case we wanted to ask them what they saw or anything of that nature.
So let me ask this question. Who was the violation against? Who committed the violation? The young lady that just
Well, that's a big question to me too, because it's just against Blue Ribbon's license. So I don't think it's an individual that did anything. It's like, that's why that's part of our concern.
Okay, so I
Chair,
will.
if we could just start by, have we called the case?
Yep.
Before? Okay. If we could,
Yep.
Just, Ms. Prosecutor, did you get a witness list?
I did not receive a witness
Does
list.
the fact that the representation of the defense attorney satisfy your notice of the witnesses?
In that they're here in case I have put any questions.
Well, I'm asking you, are you satisfied with the notice that the defendant has given you notice of witnesses that he's going to be called?
Yeah, I'm satisfied.
Okay.
It's not going to be anything surprise or anything. It's just if you want to ask them, they're here. That's all I'm saying.
Do you plan on asking your client and your client's witness questions?
Not unless something. Well, only in general they were there, and they were closed. I can make a representation to everybody. If called, they would testify. They were there. They were closing up. It was the end of the shift. They would. She will testify that these.
I think we're getting a little bit ahead of them. A little bit ahead.
Okay, but it's nothing going to be.
You're
nothing
explaining
surprise.
your position to us. We want to hear the charge and go forward from there.
Okay.
Yeah.
Then I can make an offer of proof at the appropriate
So
time.
let's start off agenda item number 27, Blue Ribbon Bar and Grill. Please introduce yourself for the record again, sir, and your client.
Good afternoon. My name is Grant Kidani. I am appearing here with my client, Ms. Pam Higa, who is the sole member, owner of Blue Ribbon Bar and Grill LLC, doing business as Blue Ribbon Bar and Grill.
Introduce myself.
Yes.
Joy Neely, Deputy Corporation Counsel appearing on behalf of the Liquor Commission.
For the record, read the charge again.
On or about December 16th, 2017, in the city and county of Honolulu, state of Hawaii, licensee permitted Joseph Texera to possess or distribute illicit or illegal drugs on the licensed premise in violation of Rule 38478.05a of the Rules of the Liquor Commission of the city and county of Honolulu.
And proceed, please.
Deny, not guilty.
Deny. Okay, very good. Okay, are you prepared to start?
Yes, I'm prepared. I also have one exhibit, and that's just the investigation report.
Okay. All right. You can make an opening statement.
Okay. Well, on December 16th, 2017, Liquor Commission investigators arrived at licensee's premises Blue Ribbon Bar and Grill, and almost immediately upon arriving, they noticed a customer within one of the karaoke rooms who appeared to be trying to block the view through the door's window. This was suspicious to the investigators, so they entered the room, and upon entering, they noticed 3 male customers seated. One of the customers reached forward to the table and grabbed a clear plastic bag containing a white powdery substance. And subsequently, the investigator asked this customer to step away from the bag, and the area was secured. And HPD arrived.
Sure, would you like
Oh,
to make?
sorry, one more thing. So the rule in question is 38478.05, which states the possession, distribution, or use of illicit or illegal drugs or narcotics on the licensed premise by any person is prohibited. So because licensee violated this rule because illegal drugs were found on the premise, and so the recommended fine for this first violation is $500.
Sir, would you like to make an opening statement?
Can we reserve until our case?
Okay, fine. Okay, ma'am, call your first witness.
Okay. My first witness is Glenn Nishigata. Should I distribute exhibits now? Should I distribute them now? Can I move my exhibit into evidence?
Are there any objections, Mr. Kadani?
Yeah, let me make sure it's the same thing.
It's the same thing, but attached is color photos in the back. Oh, he's part of it.
Did he sign it? Oh, this is his signature? I have no objection to what he signed. But whatever he didn't sign, I guess I do object. But whatever he signed, I have no objection.
Okay, the rules of evidence are relaxed in this administrative proceeding.
Yeah.
We will consider the exhibit over the objection and we will give appropriate weight.
Okay.
Thank you.
I'll need one of these back because I'll have to mark one for the record. But until that time, I'll I'm going to go ahead and swear the witness
Yes,
in.
go ahead, ma'am.
Do you swear that the testimony you give today's hearing will be the whole truth, nothing but the truth?
I do.
Thank you.
So just to be clear, the exhibit was moved into.
It was accepted by the commission.
Thank you. So please state your name.
First name is Glenn, last name is Nishigata, Nishigata.
And what is your occupation?
Liquor Control Investigator with the Honolulu Liquor Commission.
How long have you been employed with the Liquor Commission?
A little over 2 years.
And were you assigned to investigate Blue Ribbon Bar and Grill located at 1831 South King Street?
Yes.
When did you conduct your investigation?
It was December 16, 2017.
Okay. Did you work with any other investigators?
I was assigned to work with temporary assignment Michaela Meadow and investigator Arthur Tupola.
And what were you assigned to investigate?
Do a compliance inspection of the licensed premises to make sure they're following all the rules and laws of the Liquor Commission.
Can you please tell us what you observed?
We arrived and entered at 01:25 hours on December 16th, 2017. Proceeded into the door, broke to the right where the karaoke rooms are. In karaoke room number 2, I observed a male standing inside the room where the window was, using his shoulder and back to block the window.
Okay, and well, you wrote a report regarding.
Correct. Regarding finding.
Okay, so is this the report regarding the incident?
Yes.
This is Exhibit 1. Okay, and can you tell me what this is?
This is a violation investigative report on Blue Ribbon Bar and Grill.
And is it kept in the ordinary course of business at the Liquor Commission?
Yes.
Okay, so can you turn to page 12 of this document? Can you explain what this is?
This is the floor plan of the licensed premises of Blue Ribbon Bar and Grill.
Okay, so upon entering from the main door, how long did it take you to notice this individual obstructing the view of room 2?
Approximately 30 seconds from when we entered.
Okay.
30 seconds to 45 seconds.
So, were there any other employees around?
I believe I did see a bartender behind the bar and a server in the establishment.
Okay. Did they have a view of this room as well?
They had a view of the room.
Okay. So turning to so let's see. After you saw this individual blocking the window of the room, what happened next?
It seemed like he was intentionally blocking it because he was looking back and using his shoulder to obscure the view inside the room. So I notified investigator Tupola, at which point he proceeded and he opened the door.
Okay, so turning to page 15, or this is exhibit C of the colored pictures if you turn to the back. Okay, can you describe what this is?
This is the glass window on the karaoke room door number 2.
Okay, so even though there was an individual obstructing the window, you could still see in?
I could see, he didn't obstruct the whole window, so I could still see 3 other patrons inside.
Okay, and please describe what happened after you entered.
Investigator Tupola opened the door. He broke to the right of the room. I went straight ahead, and I seen a male later identified as Joseph Texera sweep off the table a white clear Ziploc baggie with white powdery substance inside.
Okay, so can you turn to Exhibit B, which is in the color photos? So that's at the back of the document. Can you identify what this is?
This is the clear Ziploc baggie with the white powdery substance that Joseph Texera picked up off the table.
Okay, so after he picked it up, what did you do?
I identified myself as a Liquor Commission investigator with my badge and credentials, and I asked him what's in his hand. At that point, he opened both hands, and the baggie fell to the floor.
Okay. And then what happened?
At that point, I asked Mr. Texera to step to the right where the other 2 gentlemen were sitting, and I stood over the baggie to secure the area so nobody could touch the evidence.
Okay, so do you have any training or experience that led you to suspect the bag contained an illicit substance?
My prior work experience, 18 plus years as a manager with Longs, and about a year loss prevention with Longs. I've dealt with several instances where we found Ziploc baggies with white powdery substance that we call HPD, and they verified it was drugs.
Okay. And based on your experience, what did you believe the substance in the bag to be?
It looked like cocaine to me.
Okay, so turning to page 5 of the Exhibit 1, the investigative report. Can you tell me what this document is?
This is a notice of violation to Blue Ribbon Bar and Grill. Under the Rule 384-7805A, which lists drugs and other illegal activities.
Okay, and this is a fair and accurate copy of the citation you signed?
Correct.
Okay, is this citation kept in the ordinary course of business at the Liquor Commission?
Yes.
Okay, and all that, did everything you just testified to occur in the city and county of Honolulu?
Yes.
Nothing further.
Commissioners, do you have any question of the witness?
Mr. Nishigata, I heard your testimony that you believe the white powdery substance in the Ziploc bag was cocaine.
It appeared to be.
Did you ever learn from HPD that they tested the contents for what it was?
This instance here, I have not been aware of what was the prognosis or the outcome of the testing.
HPD came while you were still at
Correct. They took custody of the evidence and arrested the individual.
Any further questions from the commissioners? Dr. Cross?
Just briefly. Okay. I'm sorry. Is it Nishigata?
Nishigata.
Okay. Can I just call you Glenn?
Okay, sure.
Easier. Okay, Glenn. Your what's your formal educational background?
Education, graduated high school and approximately 6 months of college.
Any and let me cut through the basic questions. Were you in law enforcement?
No.
Okay. Were you special training in chemistry?
No.
Any special training in lab work, identifying chemicals?
No.
Just let me give it to you straight. Isn't it true you have no knowledge personally what the substance was in the bag?
Personally, no.
Okay. And personally, you are not witness to any lab tests, etc., which would prove what the substance was. Were you?
Not
weren't
personally.
present.
Not personally.
All you can attest to today is basically hearsay what somebody else said.
I assume so. I mean,
well, you testified earlier that you talked to HPD. Who did you talk to that said it was cocaine?
On this instance,
yeah,
they didn't tell me it was cocaine.
Okay, so you don't know.
Not personally, no.
Okay. I have no further questions.
No further questions.
Your position?
I didn't know the issue of it being cocaine was in dispute because I have turned over the HPD report to licensee, so they're aware that the lab results did show that it was cocaine.
Do you have any further witnesses?
No further witnesses.
Present your side.
Okay. I have no further questions.
Yeah.
Hold on, 1 second. Yeah.
Oh.
We need take a recess.
Okay.
Ask for a recess.
Oh, sorry. May I request a recess?
Yes. Can you shut my video?
Glenn's excused.
Yeah, yeah, good.
Yeah, let's get back on the record.
Get it back on the record. Okay, here we go. Okay, we're now back on the official record. We will continue on. Madam Prosecutor, you have a request.
Yeah, I'd like to recall the witness Glenn Nishigata.
Do you have any objection?
Obviously, but it's your
No
show.
objection is noted.
So noted.
This witness has already been sworn, so I'm not going to.
Thank you, Ms. Harai.
You're still under oath, Mr. Nishigata.
Excuse me?
You're still under oath.
Okay, thank you.
Okay, so if you turn to page 3 of Exhibit 1, is this the report you wrote?
Correct.
Okay, and does it reference an HPD report that was generated from this
Yes.
incident? Okay, and what was that HPD report number?
HPD report number was 17-474164.
Okay, I'd like to introduce HPD this report into evidence.
Objection.
Objection based
Hearsay. Police reports are purely hearsay, and unless you have a person that is an eyewitness to what's contained in the police report, in a court of law, they don't come in. This, I understand, this is not a court of law, but still, it's all hearsay, and you cannot bring in hearsay to any extent. And also, contrary to what counsel said, my second objection is that this is all we were provided. We weren't provided with anything else other than this, and this does not contain any police.
I'm sorry, for the record, what is this, counsel? What are you referring to?
Basically, this is what they put into evidence, but we also got a copy from paid for from here. But also, it's the same thing that they put into evidence.
Just to be clear, you're referring to the exhibit that has been admitted?
Yeah, Exhibit 1. I'm sorry.
Thank you.
But okay. But anyway, my objection is basically that you can't put in hearsay evidence to give any clear and convincing or.
Okay, so let me ask this question.
Yeah.
Right, okay. The evidence that you're going to introduce is included in your report.
Not in my report. I just based the report number, the HPD report number, in my report.
Yeah, Mr. Kidani, your objections are noted, but as I mentioned earlier, the rules of evidence are relaxed. In fact, Section 3-85-91.5 says that the admissibility of evidence at an adjudication hearing shall not be governed by the laws of evidence, and all relevant oral or documentary evidence shall be admitted. So we will accept the exhibit offered by the prosecutor. As I mentioned earlier, we'll give it appropriate weight, but I do think out of fairness, Ms. Neely, you should provide Mr. Kidani an opportunity to review the exhibit.
I actually did email him this report last week because I intended to subpoena an officer to testify this, but he didn't. It wasn't served in time, so he was unable to appear today. I mentioned this to opposing counsel, and requested a continuance, or to see if he'd be amenable to a continuance, and he said he didn't want to continue again. He wanted to carry forward the hearing, so that's why.
And the representation by the counsel was that he did not receive it, and I think out of fairness, we ought to at least give him a copy and maybe take a short break to give him that copy.
Well,
I don't need a copy. I can review it after she gives it to me, but we can continue. I don't want to hold you guys up for dinner or anything.
Okay, so I want to make sure it's fair. I want to be
Fair,
sides.
we got all.
Yeah. No. I can do it quickly while she's finishing.
You can review the report?
Yeah.
This is the email you responded to, so I'm trying to see.
Okay, I see.
Okay, so I move to enter the police report into evidence.
We should accept. This is gonna be exhibit 2.
Correct. It's not marked.
We'll accept it as exhibit 2 on March.
And for the record subject to Mr. Kadala's objection.
Thank you.
Right. I would also note for the record that this report is referenced in the investigative report as well.
Okay. I only have one copy right now, but is there a way to mark that page? That's the page with the lab results.
I can just have this back so I can mark it as the, in case we have to do a record. I'll just focus it on that. Off the chair.
Please proceed. I have no further questions.
Commissioners, do you have any questions? No questions.
Thank you.
Thank you.
You have no further witnesses, are you going to rest?
Yes.
Okay.
Kidan.
So, can I give
Yes, sir.
just my statement?
Yes,
Okay.
please.
Basically, our position is that the charge that was read several times today claims that we are in violation, or I'm sorry, Blue Ribbon is in violation due to the licensee permitted Joseph Teixeira to possess or distribute illegal drugs on the licensed premises. We denied that because at no time did Blue Ribbon permit in any way anyone to come on the premises to do any type of distribution, possession, or distribution of any drug. That's number one. Number two, over the course of 12 years, Ms. Higa has run a very clean operation. This is the first time any kind of drugs was brought in. There was no history of these college kids having any background or drug type of problems. She will testify that these young college people were always courteous, kind, never any indication whatsoever that they were in any kind of possession of any drug, and they never caused any trouble. So, based upon that, the evidence will be that the licensee had no knowledge, no reason to know any wrongful, illegal activity occurring on premises, and certainly did not permit as charged any such action. We believe that the evidence will show that these things are unfortunate, but the culture we live in, we don't search patrons coming in to the restaurant or the establishment. It's just not done. And we believe that, and I don't want to get into the legal issues right now, but we will submit our legal argument at the end. But the evidence will state that there was never any indication, suspicion, indication, or any form of notice that would require Ms. Lee to be responsible as charged. Never would happen. She does not agree with drugs. If I ever found out, my sister-in-law would be in big trouble. But this is not a permitted activity on this premises. Has never been, never will be. And these charges we're fighting is because it's defamatory. She would never agree to this type of thing on her premises. We can get into testimony, but what the attorneys say is not evidence. But I'd be happy to have her examined first and then open it up for the panel, the commission. And also we have the worker on the floor that night, Ms. Stacy S. Pajicho. Good girl. She's a professional real estate property manager. She polices the place well. She's a local girl. Drives in from Waianae every day. And never any suspicion of any such activity going on this premises. And these people were here several times prior. Now they're completely barred from the premises. But the point is, we had no suspicion, no knowledge, no acquiescence, no consent, zero tolerance for this drug situation.
Okay, thank you very much. So call you witness.
Okay, we'll call Pam Higa to testify.
Oh, hi. This is Kyungmi Higa.
I'm gonna swear
Pam.
you in.
Yes.
Okay?
Oh,
I swear that the testimony you give in today's hearing will be the truth, whole truth, and nothing but the truth.
yes, I'm telling the truth.
Please state your name for the record.
I'm Kyungmi Higa, Pam Higa. I call American name Pam. So I met them about.
Wait. I have to ask you a question.
Yes.
Okay, first of all, I don't know if I asked this, but how old are you?
I'm 57.
And what is your relationship to Blue Ribbon Bar and Grill?
It's my business.
You own everything?
Yes, I own everything.
How long?
100%.
How long have you operated Blue Ribbon Bar and Grill?
11 years.
Okay, wait for my question. Okay. So approximately 11 years, and over the course of that 11 years, did you have a liquor license?
Yes.
Okay, and at any time during the history of Blue Ribbon Bar and Grill, well, first of all, you were always an owner of Blue Ribbon Bar and Grill?
Yes.
Okay. And since that time you started the business until currently, has there ever been any drug charge or activity or any problems with drugs on the premises?
No.
Okay. And let's just go to the date of on or about the time of December 16, 2017. Apparently there were some people that came into the karaoke room. Just briefly, who were these kids that were here?
This customer, this Caucasian, these all American boys. They some UH student, college, and some not. I'm not really 100% know everybody, but I met Joseph. He was such a nice boy. When they come in, they was very sociable. They hi to everybody. They was all aloha, everybody. So I never thought they do such a things like that. Stand my back as doing that.
Okay. At any time prior to December 16, 2017, did they ever cause any trouble in Blue Ribbon?
No.
Did you know them outside of Blue Ribbon?
No.
At any time, did you ever see any drug or white powdery substance or anything of that nature?
No.
Okay. tell us about December 16, 2017, what you can remember.
I remember, every Friday we kind of busy, and then I was in the kitchen washing dishes, and then one of my girls called me, liquor commission walk in, and then they went inside. They found something violation, so I walk out, and then I was still talking to one of the liquor commission lady, what's going on, and then she said, we found something on the table. Also, how you can could you guys can see. So all we can see, we have knowledge of that. Then after that, the policeman come in. Then after I found out, they said on the drug, but that time was 1:30, and then we last call for the night, and then all the girls busy. Then we so busy to pick up all the glass, clean up everything to last call for the people. So we cannot focus what people, the customer doing. Then that's how it happened. So so now we're banning them. They're not allowed to come back.
Okay, in terms of your worker there that night, is that Stacy S. Pijo?
Yes.
Okay, and she's waiting outside, right?
Yes.
And she was there all night and observed everything there?
Yes. We have three girls working, and then every Friday, Saturday, one girl focused to a room because we want to know what's going on, what they're doing. So we on the floor, three girls, but one girl always focus, serving room. That's how it happened. This was closing time, so everybody was busy. That's how it happened.
Okay. No further questions.
Commissioner, do you have any questions of the witness?
I have a question. Do your employees, do they periodically go into rooms to check on the activities of your patrons inside of the rooms?
Yes.
How often do they check?
We cannot say exactly how many minutes because Friday always busy. So when three girls working, one girl focus in the room, and then two girls still serving room 2. Then every I don't know how to say, maybe 10 minutes, maybe 15 minutes, and then two other girls always passing. We have a window that we can see the customer, you guys okay, like silent, sign. And then one girl always go in there to see what they're doing.
And if one of your employees is doing the checks and checking on the rooms, if there's someone standing in front of the door, the window, do they go into the room, or what happens if someone's standing in front of the door?
You know what? Because we have room 1, room 2, and then most time there was a lot of guys in there. Joseph group is a lot of guys, and some people they're just standing and drinking. So we cannot say you guys wait at the door. You guys gotta sit down. We cannot control of that.
So if someone's standing in front of the door, they don't go in and check?
By the door, but sometimes they're talking story, they're singing, they're standing, and then they're singing. We don't know what they're doing. We know that they're singing, they are talking to friends. So we never thought they do such things, doing something illegal. But we very focus what they're doing, what they're over drinking, they bring in to alcohol. We are very focused of that. But we never thought they do something.
Thank you.
I have a follow-up question. Ms. Higa, if I heard you correctly, let me ask this question. Do you have a policy and procedure for your employees what to do, if anything, if someone is blocking one of the windows to the karaoke room?
No.
Okay, thank you.
Prosecutor?
So as a licensee, you're aware that you're bound by the rules of the Liquor Commission, correct? You have to follow the rules of the Liquor Commission.
Yes.
And you know that Rule 3-84-78.05A prohibits anyone from possessing illegal drugs on the premises, regardless of whether you know about it or not.
Objection. Asking for legal conclusion.
Objection noted, but she can answer the question. Do you want her to restate the question? Your lawyer made an objection, but we want to hear the testimony.
Oh, okay.
Do you know that Rule 3-84-78.05 prohibits possession of illicit substances on the premises?
I never thought people does drug in the property. I never thought because when they go in the room, so many people.
Were you aware of the rule against having illicit drugs or substances on your licensed premises? Did you know that that was a rule?
No.
Okay. And you mentioned in the last 11 years you haven't had any violations, liquor violations?
No. Drug violation.
Okay.
Misstates the testimony.
You have had other violations, correct?
Yes.
I don't have any questions.
No, you have another witness you'd like to call?
Yeah, but it would only verify if there's any question by the commission or the prosecutor about the other workers seeing anything. She's just going to verify basically the fact that there was no indication that they were doing drugs in that room or any history of that.
Okay, we can accept that offer.
Okay, but I just wanted to have somebody else here in case you had questions. Okay, you can tell her she can.
She can come in.
No, she can go.
Yeah, she can.
Why don't you let her go? She's been waiting. Why don't you let her
That's
go?
okay. I'm gonna have
Okay.
dinner.
Okay. Okay, so basically that's all we have. Other than legal.
Well, the possession of illegal drugs is a violation of Rule 384-78.05A. On December 16, 2017, investigators found a customer with a substance that turned out to be cocaine. This rule doesn't require knowledge or a past history to suspect that there might be drugs. It's just if there are drugs found in possession of someone on the premises. And even if knowledge were a requirement, I mean, the investigators arrived and saw the suspicious activity within 30 seconds of arriving. So accordingly, there were legal drugs on the licensed premises, so the Liquor Commission recommends a penalty of $500 for this first violation.
Would you like to say anything?
Oh yeah.
Okay,
yeah, for
your closing argument.
Yeah, for the record.
Thank you.
With respect, and I understand the statute or your regulation, etc. For the record, I need to be clear on our position. The charge here was that, as stated and as read, was that the licensee permitted the possession or distribution of a drug on the premises. That's what the charge says. Well, they can argue whatever they want to. Number one, they did not prove beyond clear and convincing evidence, which is required, that this licensee ever permitted drugs on the premises, number one, and never permitted a distribution of illegal drugs on the premises. That's the charge. If they want to make a different claim, okay, that's fine, but we believe that they have not proven by clear and convincing evidence under the law that this charge is valid, and they have the burden of proof. Number two, they claim, and maybe they're right, knowledge isn't necessary. But if you're going to punish somebody, it's just common sense that you're going to punish them for doing something wrong, where they knew or should have at least known some type of conduct on their parts was beyond what this commission would allow. And without that knowledge, you cannot punish people for criminal acts that we never at any point had notice, suspicion, or any possible evidence that this was going on. And I think that under American constitutional law, statute and charges have to be clear. You cannot just be making wild accusations about activity that an owner of a business does not understand. These type of statutes have been routinely voided for vagueness, unenforceable under the 5th and 14th Constitution of the United States, as well as the same type of procedures under the Constitution in the state of Hawaii. The 5th and 14th Amendments of the Constitution require fair process, due process, and equal protection under the law. Under the terms of these types of regulations, even if they are considered to be a penalty of sorts, they still have an element of requirement, at least in our view, of an act or conduct that was done that violates your public policy. This is not a true criminal situation, but they say in those cases, there has to be what they call actus reus. There has to be an act that they knew they were doing was wrong. And then you have the mental side, which they're saying there's no requirement of knowledge. I don't believe that's true, because you still need to have a suspicion you're doing something wrong, or in criminal law they call it mens res. And then the third step is you need a causal connection between the two. They have not proven any of that. And it's their burden to prove by clear and convincing evidence that this all occurred. And I believe, as an officer of the court, and similarly to you, my job is to guide you to what I think the law says. And the law says that in these type of situations, due process under 5th, 14th Amendments requires that they prove by clear and convincing evidence that these requirements have been met, and they have not. This is what they call a fundamental right under the 14th Amendment. It's a right protecting entrepreneurs from overregulation, and also it is, in my view, a non-fundamental right which requires a rational basis under the Constitution. So, in this type of situation where you're going to have consideration of a penalty and to punish a business owner, and they're all trying to make a living, you still need to follow the rule of law. And I get it, you know, the rules of evidence is lax. I get it that the procedure that is being followed is to process, but I think you still have to be, and I am, and I think the commission has to be, a gatekeeper and a guardian to prevent abuses. And where a regulation like this is so vague and ambiguous, where I can't tell when I read it, and okay, maybe I'm a lawyer and I read into things, but who is this supposed to be really punishing? Do you punish if somebody comes into this room and has drugs, and the HPD comes in and busts him, and do they arrest all of you because you're in charge of this room? That's ridiculous. And I think similarly, you as guardians and gatekeepers of this type of important, and I agree with you, it's an important part of our society. As gatekeepers, you have to look at this rule and say, hey, wait a minute, is this directed really at the licensee when they have no notice, no knowledge, and these criminals do some act which is obviously not condoned by our society? And I say to you that this provision, I tell you honestly, is illegal. And I don't want to cause trouble, but I just don't think it's right to penalize people in our society when criminals do something wrong. I think it's wrong. I think that these type of statutes, it's my job to tell you and advise you that these type of regulations are inadequate, to me, not legal. I understand it's your job to enforce the rules and regulations, but as gatekeepers, you need to look at the evidence in this case. And I think that when you look at the evidence and you see how it violates not only the law and the Constitution, but human conscience, they haven't proven a case that they permitted this. And that's the charge I'm reading. That's what's on the record. And that's what we believe they failed to prove. We rest. Otherwise, we've stated everything we need to state.
Thank you very much. Could I
Chair,
have a
I'm sorry, just a point of information, if I may. Under rules 3-8591.5, the proof, the burden of proof is, for these proceedings, are preponderance of the evidence. Just for point of information.
Thank you. I have a few questions for you, Mr.
Sure.
Giuliani. You do understand, or would you agree with me that the issuance of a liquor license is a privilege, not a right?
Correct.
Do you have any authority for your constitutional arguments that they apply to regulations?
Yes.
What's that authority?
I did some research on.
Appreciate that.
Anyway, yes, under constitutional law, and I'm giving you some general sites because I didn't really get into the details, but there was a most important case by the United States Supreme Court called Sutherland in Honolulu versus General Construction, 269 U.S. 385 399, 1926. And I didn't have time to really bring it all the way forward, but it talks about and elements of penal types of statutes and then regulations then it gets into these issues about again, this may be I'm looking at citations of law through our research facilities, and it did and if they amended the laws here differently, okay, that's fine. But most civil penalties in the court's jurisdictions we looked at said it had to be clear and convincing evidence.
Let me stop you there, but what was the administrative rule or regulation issued in Honolulu?
What?
You said the Constitution applies to the Supreme Court case of Honolulu, and I was
Well,
wondering what is
yeah, it was
what kind of administrative rule regulation?
no, again, I didn't read the statute. I have to admit that. I was just taking the general statements that they were making that says the void of vagueness doctrine is a constitutional rule. The rule requires that criminal laws are so written that they explicitly and definitely state what conduct is punishable. The void for vagueness doctrine thus serves two purposes. First, all persons receive a fair notice of what is punishable and what is not. And second, the vagueness doctrine helps prevent arbitrary enforcement of the laws and the arbitrary prosecutions. So again, I apologize. I didn't get to drill down upon the specifics of these type of cases per se. I did try to get the grasp of the issues of what I think is the heart of the matter is these what they call fundamental rights under the Constitution, and that's a little bit different.
Yeah, thank you. So, but I think I heard you when you're summarizing the Honolulu U.S. Supreme Court case.
Yeah.
It applies to criminal case.
Well, they were talking about any kind of penal type of laws, but it does transform down to civil penalty also. And again, anytime you're going to punish somebody, whether it's criminal or civil, you have to be clear. It cannot be vague on the regulation, and I'm more than happy to follow up and give you the citations, but regulations that are vague are routinely scrutinized by the courts and are challenged, and it has to fulfill the requirements of 5 and 14 of due process.
Thank you. Madam Prosecutor,
Any rebuttal?
your final rebuttal.
I disagree that with the implications that there was lack of notice or that the rule in question is vague. Both the citation and the notice of hearing all cite to a specific rule which is pretty clear in stating no illegal drugs on licensed premises. So I think that's it's pretty clear there has been a violation. There isn't a knowledge component to that rule. And again, even if there was, I mean, there were 2 employees working there, and to what was apparently a pretty obvious suspicious activity, and no one made any effort to check in the room. Apparently, there's no policy to go to inspect rooms where the views are blocked. So there was a violation of the rule.
Okay, very good. So we're going to recess to deliberate this agenda item number 27. Is that correct? Yes. Now in recess. Back on the record. Okay. Commissioners, can I have a motion with respect to this matter?
Yes, Chair. My motion is to find licensee Blue Ribbon Bar and Grill LLC in violation of Rule 3-84-78.05 subsection A of the Rules of the Liquor Commission of the City and County of Honolulu.
Second.
Been moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 27. The licensee is found guilty. We have a recommendation now.
The recommended fine was $500.
$500.
Motion to approve the recommended fine of $500.
Second.
Been moved in second. All those in favor?
Aye.
I vote aye. Agenda item number 27. The recommended fine of $500 is approved.
Thank you.
Do we have
Thank you.
any administrative matter? Meeting adjourned.
Thank you.